We discuss obligations of the agent. Article 1884. The agent is bound by his acceptance to carry out the agency and is liable for the damages which through his non-performance the principal may suffer. He must also finish the business already begun on the death of the principal should delay until any danger. Take note that when an SPA is given by the principal to an agent, the same is only good for until the death of the principal. But in this particular case, in this article, 1884 second paragraph, the agent doing business or transactions before the death of the principal must have to finish the transaction even after the death of the principal. In that case, the authority is still existing ang authority ng agent. That is allowed by Article 1884. And by his acceptance, the agent must have to carry out the agency and is liable for damages. Even through his non-performance, the principal may suffer and he will be personally liable. The provision is clear that an agent is bound to carry out the agency. The relationship existing between principal and agent is a fiduciary one, demanding conditions of trust and confidence. It is the duty of the agent to act in good faith for the advancement of interest of the principal. 1885. In case a person declines an agency, he is bound to observe the diligence of a good father of a family in the custody and preservation of the goods forwarded to him by the owner until the latter should appoint an agent or take charge of the goods. So in this case, when there is supposedly a contract between principal and agent, and in executing a contract, preparatory to the execution of the contract, the principal has entrusted to the agent some properties for the use in connection with supposed to be authority given by the principal to the agent. But nonetheless, when the agent declines the agency and properties entrusted by the principal to the agent is already in the custody of the agent himself, this obligation to take care of the goods or the properties of the principal persists until after he returns the property to the principal. The degree of care that should be given is as stated in Article 1885, the diligence of the good father of the family. So that's the care that should be given by the agent in taking care of the things entrusted by the principal to the agent when eventually the agent declines the agency. Okay. Article 1886, should there be stipulation that the agent shall advance the necessary funds, he shall be bound to do so except when the principal is insolvent. So in the case when a principal has to let the agent do something, say travel to some places and do transactions there, and if the funds given by the principal to the agent is not enough to conclude effectively the transactions that is bestowed upon the agent in that particular place, then incumbent upon the agent to advance the funds, siya na mismo ang maggastos. Of course, take all the receipts on where the funds are applied, and of course have it refunded to the principal as soon as the agent returns to the place, to the principal. Example, P and A agreed to enter into a contract of agency. One of their stipulation among others is for A to advance the necessary funds for the payment of office supplies, inventories, electricity, water, and telephone expenses. In this case, A must advance the necessary funds. It is understandable, however, that P will reimburse it. However, A need not advance the necessary funds when P becomes insolvent, meaning when P has greater liabilities than his assets, because it is logical that P cannot reimburse him. Article 1887. In the execution of the agency, the agent shall act in accordance with the instructions of the principal. Naturally, you are not authorized if you will not follow whatever the principal has made you to do, under the authority. In default thereof, he shall do all that a good father of a family would do as required by the nature of the business. Still talking about the diligence of degree of diligence, degree of care that should the agent do in taking care of the business of the principal. The agent shall act in accordance with the instructions of the principal so that he will not be liable to the principal for damages in case of failure to accomplish the purpose of the agency. In the absence of instructions, the agent shall observe the diligence of a good father of the family. So kung wala instruction, good father of the family ang iyang himuon nga i-apply as diligence. Be appointed A as his agent to sell his only car. In the special power of attorney given to A, the latter was authorized to sell the car for a selling price of 500,000 pesos. However, B verbally told A that he can give a maximum of 10% discount based on the selling price or a maximum of 50,000 pesos discount to any willing buyer. In this case, the authority is to sell the car of 500,000 pesos. However, in accordance with the instruction, A cannot sell it below the selling price of 450,000 pesos, inasmuch as the maximum discount to be given is 50,000 pesos. While if A sold the car for 430,000 pesos, then A may be held liable for damages for violation of the instruction. Nonetheless, the contract of sale between A and the third person buyer is perfectly valid because the instruction is not binding as to third person. Take note that it is only the authority which is binding to the third person. Article 1888. An agent shall not carry out an agency if its execution would manifestly result in loss or damage to the principal. Maklaro man na ba? Whoever, if you are a good person, worthy of your kind, you should be able to know the risk of the transaction with which you will be doing with in the future. Like foreseeable transaction, and you would know that doing the transaction would make you loss, would result to losses. Okay, particularly in your person. However, you are representing another person, that is your principal, and the losses eventually will fall upon the principal. So you would need you just tell the principal about it. Because if the principal insists, then that's the time that you will go through with the transaction, even if you have already told him that it is for a loss. Example, P appointed A to manage his strawberry farm for the current year. Further, P planned to plant strawberries on June 1, 2007. However, it was forecasted by the proper authority on May 28, 2017 that a strong typhoon is coming within a week. As a consequence, A did not plant strawberries on June 1, 2017. Is A liable for damages? The answer is no, because what he did is for the protection of the principal. Otherwise, it would have resulted in loss or damage to the principal. Article 1889. The agent shall be liable for damages if there be a conflict between his interest and those of the principal. He should prefer his own. Another example, this is particularly an example suited to Article 1889. B and A are owners of adjoining lands. B appointed A as his agent to sell the former's land. Thereafter, X, a stranger, expresses to A his desire of buying either the land of P or his land. In this case, A can only sell the land of P to X. A cannot sell his land to X because of conflict of interest. Otherwise, he will be liable for damages. Article 1890. If the agent has been empowered to borrow money, he may himself be the lender at the current rate of interest. If he has been authorized to lend money at interest, he cannot borrow it without the consent of the principal. Take note, the agency here is two kinds. One is that the principal wants to borrow money, so of course from the other person. So if you are the agent, you will borrow money representing the principal from third person. So, but however, you yourself can lend the principal. So, being an agent as well as the lender yourself, pwede ba siya? According to Article 1890, pwede siya, he may himself be the lender at the current rate of interest. Basta current rate of interest lang po. If he has been authorized, is the other way around, has been authorized to lend money at interest, this time, it is the principal lending money then siya lang ang ipagamit. He is the agent now lending money to others. And in this case, he cannot borrow it without the consent of the principal. So nanay kwarta gihatag ang principal sa imuha, and then you would want it to lend to other persons at interest, but you yourself is in need of money at that particular point of time. Can you borrow from the funds given by the principal? The answer is yes, provided that the principal give his consent. Otherwise, you don't, no? Article 1891, every agent is bound to render an account of his transactions and to deliver to the principal whatever he may have received by virtue of the agency, even though it may not be owing to the principal. Every stipulation exempting the agent from the obligation to render an account shall be void. Naturally, pag nakay secretary or agent, imong patuwa na siya dito, tagaan imong funds for that particular transactions or series of transactions. And then, he returns back reporting his accomplishments. Of course, kakibat dito sa accomplishments kato mga expenses nga iyang gi-incur while doing the transaction. Now, included sa iyang report is not only his accomplishment of the transaction but also all the things that he did spending the funds by the principal, no? The funds of the principal. So yan i-report na siya, i-account niya na tatanang pangatag sa principal sa iya, ha? So that the principal would not be suspicious as to where the money goes, no? Iyan na siyang ilista gina tanan along with all the receipts, no, sa mga panggasto, no. Yan, mga gwapo buhaton sa agent. So kanay stipulation exempt sa agent from the obligation to render an account, it shall be void, no. Dapat dili gini siya i-allow. Every agent is bound to render an account of his transactions and to deliver to the principal whatever he may have received by virtue of the agency, even though it may not be owing to the principal. Every stipulation exempting the agent from the obligation to render an account. Article 1892, the agent may appoint a substitute of the principal. A substitute if the principal has not prohibited him from doing so, but he shall be responsible for the acts of the substitute. 1. When he was not given the power to appoint one. 2. When he was given such power but without designating the person appointed was notoriously incompetent or insolvent. All acts of the substitute appointed against the prohibition of the principal shall be void. Now take note, if there is no prohibition to make a sub-agent, to engage a sub-agent, then he can engage a sub-agent. And in accordance with Article 1892, provided that all the instructions of the principal must be followed. And if ever it is not followed and result to damage, then the agent will have to answer for the liabilities, including that made by the sub-agent that he has engaged. Article 1893, in the cases mentioned in numbers 1 and 2 of the preceding article, atong basahan ng 1 when he was not given the power to appoint one, and 2 when he was given such power but without designating the person appointed was notoriously incompetent or insolvent. So, the principal may furthermore bring an action against the substitute with respect to the obligations which the latter has contracted under the substitution. Substitute or sub-agent, a person to whom an agent has delegated the performance of an act for the principal. A person designated by an agent to perform some duty relating to the agency. It must be pointed out that the law on agency in our jurisdiction allows the appointment by an agent of a substitute or sub-agent in the absence of an express agreement to the contrary between agent and the principal. Muna siya ang presumption, no? Kung walay agreement nga bawal ang mag-engage og sub-agent o substitute, then it can be done. Engagement of sub-agent or substitute can be done. Article 1895, if solidarity has been agreed upon, each of the agents is responsible for the non-fulfillment of agency and for the fault or negligence of his fellow agents, except in the latter case when the fellow agents acted beyond the scope of their authority. This is in the cases when several agents is appointed and they would work in one project, no? One transaction in coordination with each other. So all agents must go through with one transaction in coordination with each other. So if there is this stipulation that whatever damages that will incur by reason of transacting with the other third party through the fault of one agent, the liability of all the agents given the authority shall be solidary. Otherwise, it is joint, meaning the person or the agent who has made the fault in the transaction resulting to damages shall be only one answerable. But in solidary obligation, all of them are answerable to it, or any one of them can be made to answer for the whole of the liability or damages. That's solidarity. The agent owes interest on the sums he has applied to his own use from the day on which he did so, and those which he still owes after the extinguishment of the agency. So this is the case when you use for your own personal use the money or funds given by you, given by the principal to you. No? Instead of applying the money given by the principal to you to the expenses of the transactions that has to be done, you use it for yourself personally. So in that case, if the principal find out, there's nothing wrong about it, no? But then again, it is incumbent with your duty to account for the funds given by the principal, so that when it is found to be lacking, the sums being accounted for is lacking, you are the one responsible to pay the difference, no? From that moment on, when there's already the difference, from that moment on, incur na kay interest na up to the time that you will pay the difference of the lacking funds. Example, P appointed A as his agent and thereafter P gave a 20,000 pesos as petty cash fund for the operation of P's business. In this case, if A applied a portion of the said sum of money to his own use, like repair of his personal car, then he's liable for interest. Article 1897, the agent who acts as such is not personally liable to the party with whom he contracts, unless he expressly binds himself or exceeds the limits of his authority without giving such party sufficient notice of his powers. Okay, the act of the agent is the act of the principal. That is, with respect to the third person transacting to the agent, knowing that he's only representing a principal, By operation of law, however, if the agent binds himself or exceeds the limits of his authority without giving the third person with whom he contracts sufficient notice of his powers, the principal is not liable. So, this is the problem. The Incorporated is engaged in the business of importation and distribution of various European industrial equipment for customers here in the Philippines. It has as one of its customers I-Systems, which is a sole proprietorship owned by RD. D is the sales manager of I-Systems. From January to April 1995, T Incorporated sold to I-Systems various products allegedly amounting to 91,338. Subsequently, R&D sought to buy from T Incorporated 1 unit of sludge pump valued at 250,000 pesos, with R&D making a down payment of 50,000 pesos. When the sludge pump arrived from the United Kingdom, T Incorporated refused to deliver the same to R&D without their having fully settled their indebtedness to T Incorporated. Thus, on June 28, 1995, D&J, General Manager of T Incorporated, executed a deed of assignment of receivables in favor of T Incorporated. Following the execution of a deed of assignment, T Incorporated delivered to R&D the sludge pump. Allegedly unbeknownst to T Incorporated, R&D, despite the existence of the deed of assignment, proceeded to collect from L Power Company the amount of 365,135 pesos and 29 centavos. Alarmed by this development, T Incorporated made several demands upon R&D to pay their obligations. As a result, R&D were able to make partial payments to T Incorporated on October 7, 1996. T Incorporated's counsel sent R&D a final demand letter wherein it was stated that as of June 11, 1996, R&D's total obligation stood at 295,000 pesos, excluding interest and attorney's fees. Because of R&D's failure to abide by said final demand letter, T Incorporated instituted a complaint for sum of money damages against R&D. On June 25, 1997, D filed his answer wherein he admitted T Incorporated's allegations with respect to the sale transactions entered into by I-Systems and T Incorporated between January and April 1995. He, however, disputed the total amount of I-Systems indebtedness to T Incorporated, which according to him amounted to only 220,000 pesos. According to D, he was acting as mere agent of his principal, which was the I-Systems. In his transaction with T Incorporated, and the latter was very much aware of this fact. Did D exceed his authority when he signed the deed of assignment, thereby binding himself personally to pay the obligations to T Incorporated? The answer: Article 1897 reinforces the familiar doctrine that an agent who acts as such is not personally liable to the party with whom he contracts. The same provision, however, presents two instances when an agent becomes personally liable to a third person. The first is when he expressly binds himself to the obligation, and the second is when he exceeds his authority. In the last instance, the agent can be held liable if he does not give the third party sufficient notice of his powers. We hold that D does not fall within any of the exceptions contained in this provision. The deed of assignment clearly states that D signed thereon as the sales manager of I-Systems. As discussed elsewhere, the position of manager is unique in that it presupposes the grant of broad powers with which to conduct the business of a principal. Thus, the powers of an agent are particularly broad in the case of one acting as a general agent or manager. Such a position presupposes a degree of confidence reposed and investiture with liberal powers for the exercise of judgment and discretion in transactions and concerns which are incidental or appurtenant to the business entrusted to his care and management. In the absence of an agreement to the contrary, a managing agent may enter into any contract that he deems reasonably necessary or requisite for the protection of the interests of his principal entrusted to his management. Applying the foregoing to the present case, we hold that D acted well within his authority when he signed a deed of assignment. To recall, T Incorporated refused to deliver the 1 unit of sludge pump unless it received in full the payment for I-Systems indebtedness. We may very well assume that I-Systems desperately needed to sludge pump for its business, since after it paid the amount of 50,000 pesos as shown as down payment on March 3, 1995, it still persisted in negotiating with T Incorporated, which culminated in the execution of the deed of assignment of its receivables from L Power Company on June 28, 1995. The significant amount of time spent on the negotiation for the sale of the sludge pump underscores System's perseverance to get hold of the said equipment. There is therefore no doubt in our mind that this participation in the deed of assignment was reasonably necessary or was required in order for him to protect the business of his principal. Had he not acted in the way he did, the business of his principal would have been adversely affected and he would have violated his fiduciary relation with his principal. Okay. Article 1898. If the agent contracts in the name of the principal, exceeding the scope of his authority, and the principal does not ratify the contract, it shall be void if the party with whom the agent contracted is aware of the limits of the powers granted by the principal. In this case, however, the agent is liable if he undertook to secure the principal's ratification. Okay, that's self-explanatory, no? In a way, exceeding the scope of his authority, but the principal does not ratify the contract, then the contract shall be void if the party with whom the agent contracted is aware of the limits of the powers granted by the principal. Take note that if you are an agent, you are contracting on behalf of the principal with a third person, be sure that you have given the third party the authority given by the principal to you. Clear good ba siya ba? Lay down your cards so that whatever the third party insists on doing with you in behalf of the principal, and even though the transaction would now be beyond the authority of the agent, and yet they go through with it, then the liability will not be fall to the agent, but the third party will have to shoulder the excess liability, no? Because he already know the extent of the authority of the agent in undertaking the transaction. Example, P appointed A as his agent. A authorized to sell the land of P for 500,000 pesos on cash basis only. However, A sold the land to X for 520,000 pesos on credit. X shows the limits of the powers granted by P. Thus, the contract of sale entered into between X and A as agent of P is void. What if X bought the land on credit because A undertook to secure P's ratification, but P did not ratify their contract? Then A is liable. Conversely, if P ratified the contract, then only P is liable because the contract now is perfectly valid. Article 1899. If the duly authorized agent acts In accordance with the orders of the principal, the latter cannot set up the ignorance of the agent as to circumstances whereof he himself was or ought to have been aware. Take note of that. Only the principal is liable if he appointed an ignorant agent. Article 1900. So far as third persons are concerned, an act is deemed to have been performed within the scope of the agent's authority if such act is within the terms of the power of attorney as written, even if the agent has in fact exceeded the limits of his authority according to the understanding between the principal and the agent. Written authority under Article 1900. SPA, special power of attorney, must have to be in writing and notarized by a lawyer. Article 1901. A third person cannot set up the fact that the agent has exceeded his powers if the principal has ratified or has signified his willingness to ratify the agent's acts. However defective the contract of the agent is with respect to third party, the moment the principal ratifies his acts, then all the defects on the contracts executed by the agent are already cured. As a rule, if the agent exceeds his power, the contract is defective because it is unenforceable against the principal. However, if the principal ratifies the contract, then it becomes enforceable and the third person cannot set up the fact that the agent has exceeded his powers. Article 1902. A third person with whom the agent wishes to contract on behalf of the principal may require the presentation of the power of attorney or the instructions as regards the agency. Private or secret orders and instructions of the principal do not prejudice third persons who have relied upon the power of attorney or instructions shown them. So the third party will only rely on the written authority given by the principal to the agent, and out of the limitations of the power of the agent, he will go through with the transactions and be confined with the limitations, be confined with the authority. So that if there are other authority given by the principal to the agent which is not stated in the power of attorney, then he's not, the third party is not bound by it. The third party will deny its applicability in the contract under Article 1902. Article 1903. The commission agent shall be responsible for the goods received by him in the terms and conditions and as described in the consignment, unless upon receiving them, he should make a written statement of the damage and deterioration suffered by the same. So, this is the doctrine of procuring cause. In order for an agent to be entitled to a commission, he must be the procuring cause of the sale, which simply means that the measures employed by him and the efforts exerted must result in the sale. However, for the purpose of equity, an agent who is not the efficient procuring cause is nonetheless entitled to his commission, where he, notwithstanding the expiration of his commission, took diligent steps to bring back together the parties such that a sale was consummated. So this is an agent having commission, a commission agent being one engaged in the purchase and sale for the principal of personal property, which for this purpose, he has to be placed in his possession and at his disposal. A broker, upon the other hand, maintains no relation with the thing which he purchases or sells. He is supposed to be merely a go-between, an intermediary between the seller and the buyer. Broker lang siya. 1904. The commission agent who handles goods of the same kind and mark which belong to different owners shall distinguish them by countermarks and designate the merchandise respectively belonging to each principal. The exception to the above stated article is when the goods are mixed by the will of the owners, by chance, or by will of one owner, but in good faith. Each owner acquires a right in the goods in proportion to the part belonging to him. Especially kung ang goods is uniform, no? Like grains. One part is owned by one person and the other part is owned by the other person. And it's mixed together, the same quality of grains. And so there are only the owners are only bound to their ownership as to the extent when they declare how much they own at the outset, no? At the outset when the agency is beginning to transact these goods. No? The commission agent cannot, without the express or implied consent of the principal, sell on credit should he do so. The principal may demand from him payment in cash, but the commission agent shall be entitled to any interest or benefit which may result from such sale. Example, P appointed A as his commission agent. The former authorized the latter to sell his only car for 700,000 pesos cash. However, A sold it to X for 900,000 pesos on credit. In this case, P may demand from A the 700,000 cash, but But if A collects the 900,000 pesos, A can keep the excess of 200,000 pesos as he has no obligation to give it to P. However, it must be noted that A will take the risk of doubtful accounts or the non-payment in case of insolvency of X. But if P ratified the contract of sale if it's only of his only car for 900,000 pesos, then A is no longer entitled to the excess of 200,000, but it must be noted that P will take the risk of doubtful accounts or the non-payment in case of insolvency of X. An agent who sells the goods on credit without the consent of the principal is liable for the price of the goods. However, the agent shall get the extra benefits derived from selling goods on credit. That is, if the transaction is good. But what about if the transaction is bad? So he will have to shoulder all the liabilities. 1906, should the commission agent with authority of the principal sell on credit, he shall so inform the principal with a statement of names of the buyers. Should he fail to do so, the sale shall be deemed to have been made for cash insofar as the principal is concerned. Remember mo itong transaction kanina, 900,000 pesos sale on credit, and then ang authority niya is 700,000 pesos sale on cash. So at that particular instance, the agent must have to give the principal 700,000 pesos and wait for the collection of the payment by the other person, no? And whatever collection he has, the excess of the 700,000 pesos, which is 200,000 pesos, is here already, no? But in this case, he has to inform the principal that there are several interested persons who would want to buy the property on credit. And if he fails to do so, the sale shall be deemed to have been made for cash. Pareha na sa katong example ganina. 1907, should the commission agent receive on a sale, in addition to an ordinary commission, another called a guarantee commission, he shall bear the rest of collection and shall pay the principal the proceeds on the sale on the same terms agreed upon with the purchaser. So an agent whose remuneration is based at least in part on commissions or percentages of actual sales, commission agent typically work as middlemen between sellers and buyers. 1908, the commission agent who does not collect the credits of his principal at the time when they become due and demandable shall be liable for damages unless he proves that he exercised due diligence for that purpose. If you're authorized to collect indebtedness on behalf of the principal and then nag-due na siya, wala din mo na-collect, you will be liable for damages unless makaprove ka exercise of due diligence. 1909, the agent is responsible not only for fraud but also for negligence, which shall be judged with more or less rigor by the courts according to whether the agency was or was not for a compensation. So kung negligence on the part of the agent, then he will be responsible for that negligence.